there are many things that the National Inventory of Collateral Consequences can be used for. Obviously, to inform litigators, the defense lawyers, the prosecutors, and of course the final arbiter, the court, about what the consequences of a conviction are before we embark on resolving a case, short of trial or chancing a trial and not taking a particular plea bargain that's offered. I want to point out a couple things to you. If anyone wants to view the National Inventory, there are a couple of stations out in the lobby where you can take a look. It's a very powerful tool. I use it all the time, and typically when you advise a prosecutor of the profound and extreme consequences of some of these convictions, you can get a much better resolution to a criminal case. If you don't know what those consequences are, you're really giving up a lot of tools that you can use to reach an appropriate resolution, because if a prosecutor is aware that someone will absolutely lose their livelihood and then impair not only themselves but their ability for their children to go to school and the entire family and their future, you can really reach much better results, because prosecutors, most prosecutors, want to reach just results, not to unduly burden people that have criminal convictions. I want to mention to you also that out in the lobby is this Criminal Law Practitioner magazine. It's got excellent articles in it, and I suggest you pick one up on your way out. But look for the next issue, because many articles about this summit and in conjunction with it and thoughts that led to this summit will be published in articles in the next issue of the Criminal Law Practitioner, put out by American University Washington College of Law, so I commend it to you. I know that Steve Salzburg wrote a particularly wonderful article that we'll get to read in the publication, so please look for that in the future. I need to compliment Steve Salzburg, who with his colleagues and with our executive committee at the ABA Criminal Justice Section, engaged in an arduous, years-long journey to achieve this national inventory that will be a tremendous tool, not only to practitioners, as I just said, but also to legislators, as the judges so eloquently pointed out. Take a look. We can't possibly have 16,000 mandatory collateral consequences, actually direct consequences, as we heard from our speakers, of convictions that can all be sensible or are reasonable, and we heard that many of them are not. And some reach to the ridiculous, as we heard my fellow chair, Jim Fellman, point out at the beginning of this program. We heard from so many high-level stakeholders and high-octane players in criminal justice reform here and in administering criminal justice. I see many elected prosecutors. We have our judges here, policy makers, and those who suggest policy to our change makers and game changers. We've heard many thought-provoking and provocative things here, and in an atmosphere of collegiality and in healthy debate. It's we expected very important people to come here today. What we didn't expect was how open and inspirational the things that we heard were. And as our keynote speaker mentioned, Ms. Johnson, at lunch, it is through these stories, it's through these conversations as well that we see change. And so our hopes for this summer were not as high as what has resulted. Our expectations were far exceeded, and we're gratified for everyone that participated and for all of you who have stayed and what you'll take away from this. We heard from our ABA president, William Hubbard, who not only took the time but is deeply involved in criminal justice issues, a civil practitioner, as you heard, and he's greatly promoted our efforts at decriminalization, addressing over-incarceration, and has now helped us roll out this important Collateral Consequences Summit in our national inventory. Very appreciative to Amy Solomon for joining us, a senior advisor to the Assistant Attorney General, U.S. DOJ Office of Justice Programs, and we've heard that this is a matter of national concern, that on the statewide level, we've had 30 states pass expungement laws, and we've heard many other stories about ways that courts and state houses are grappling with putting the labels put on a large community, a community of color that allows legal discrimination, and how former Deputy AG Jim Cole said that far too large a percentage of these people are people of color. We heard that these collateral consequences are not collateral at all. They're direct, they're mandatory, they're permanent, and they're incredibly debilitating. And how individuals, those that Carrie Johnson spoke about, who, quote, won the lottery and obtained some relief, a pardon by the president, or Marcel Johnson, who just had the pity of one of the probation officers who stopped talking to the court for a while, for a year, until some relief was had that quite frankly, no Texas legal vehicle really provided for. Or Charles Thornton, who achieved personal victories through personal perseverance and patience. But that helps far too few people. And so we've come together here to arm all of us and our nation with the information and the ability to pinpoint those consequences that need to be eliminated. No longer will we have to rely on these person-to-person stories of help. And I hope that all of you take that away with you. We need to stop wasting human beings and wasting human capital. And for those that are motivated by economic concerns, wasting money in a tough economy. We heard that families and generations are affected by this. We heard from Matt Riedel and how our prosecutors take a personal stake in this. It's important. Those who administer justice know this is a safety issue as well. This is something that can make lives better going forward and make their jobs less necessary. How money is better spent in rehabilitation than in warehousing people and debilitating their ability to rehabilitate and continue with their lives. We heard our speakers talk about defining moments and changing the justice system, how breaking stories may be placed in context with electronic access, but that this same electronic access to records can lead to tremendous harm to individuals trying to get their lives back on track. The scarlet letter A and public shaming is now a permanent thing. Someone can't move away any longer and start over anew. This information is too widely available. And so it thought to me, if we can have secret evidence and closed courts for special circumstances, if we can close records because someone's cooperating, or we can seal matters to help with government concerns, perhaps it's time we started looking at placing some impediments in the way when we're talking about private concerns. Something, at least making it more difficult or more cumbersome to access such sensitive records. We have to do something so that people can live and not be permanently scarred or hobbled by even misdemeanor, minor wrongs. We need to sometimes temper the First Amendment. We've recognized this in cases, for example, the attorney-client privilege. Many years ago, at the start of my legal career, when CNN had gotten a hold of General Manuel Noriega's tape recorded conversations with his lawyer and wanted to air them in public. The Supreme Court enjoined that from occurring because they recognized his right, Sixth Amendment right to counsel, at least in those very circumscribed circumstances, overcame the First Amendment. So there's a real interesting balance between the First Amendment, extremely important, and the work of our Fourth Estate, extremely important as well, weighing that against these private concerns about publicly being branded for the rest of your life for minor wrongs. Is the answer, as one of our panelists suggested, decriminalizing these minor wrongs? Go ahead and let the system break. Let's get these enormous numbers of minor wrongs out of our court system. Some would suggest that these collateral consequences are necessary for deterrence, but I think we saw that so many of them are wrong-headed. And many of us had conversations in the breaks after these thought-provoking panels that if we have a 70% recidivism rate, why is that? Is it because of these collateral consequences? Aren't we sort of letting the tail wag the dog there? We need to take another look at public versus private about maybe we don't, as I said, seal information, but maybe we put some steps in the way to obtain the information so that only responsible persons have access to it, or that require that the information be used responsibly like we use protective orders in litigation. And most importantly, we heard that judges need to have the discretion back. Why are we so afraid of that? We went with the guidelines and we took so much discretion away in sentencing, and we saw that really destroys the right to trial by jury, and also it results in wrong-headed decisions from which these jurists wish they could be relieved when appropriate. And so we should give that sentencing discretion back. Guided by guidelines or rules or principles, that seems appropriate. Wonderful suggestions as well. And I was very excited to hear that the provisions of a new model penal code will also consider collateral consequences. Steve Salzburg said this many, many months ago when we were talking about the exciting year that Jim Fellman and I look forward to, and that was, we are living in a time when all the sides seem to be coming together, whether it's for economic reasons or other reasons, that criminal justice reform is important. It's an important time that we're embarking upon, whether it's penal code reform, sentencing reform, or reform with regard to these collateral consequences. We've come to the conclusion that spending money to warehouse individuals and then releasing them into the public, as Jim Cole said, 95% of people are going to get out of prison and we're doing nothing about it. The most shocking thing about that quote is it was from the 1930s, and here we are with the same problem. We're much more enlightened. We know better what works, and we now know it is less expensive to rehabilitate and help people or divert them from the system when that is appropriate, when they have a mental health issue or a drug addiction problem. That means they shouldn't really be part of the criminal justice system. These are heady times. This summit, thanks to Jane Mesmer and her staff, and the brainchild and laboring oar behind our work, Steve Salzburger, we have an opportunity with empirical data and information upon which legislatures, individuals, and courts can act. I'd like to thank everyone for making this possible, for their year's work, putting the national inventory together, for putting this summit together, for everyone's thoughtful and provocative communications that give us all thought and gives us action plans, things that we can take and apply to make our system of justice better. And most of all, I thank all of you for your patience and attentiveness and involvement in these important issues. Thank you very much.